Okay, and we're ready for day 4 of this hearing on EO 2022-0040 and EO 2022-0193. I believe we're going to start today with David Murray for Public Counsel.
Correct.
All right. Take the stand. If you please raise your right hand. Solemnly swear or affirm the testimony you're about to give in this matter is truth, the whole truth, and nothing but the truth.
I do.
Thank you. You may inquire.
Good morning, Mr. Murray.
Good morning.
Would you please state and spell your name?
It's David Murray, D-A-V-I-D-M-U-R-R-A-Y.
Mr. Murray, did you prepare and cause to be pre-filed rebuttal testimony that has been marked as Exhibit 206 and then subsequently add an additional schedule to that testimony that's been was also pre-filed and that has been marked as Exhibit 207?
Yes.
Would those exhibits be your testimony here today, or would you have any changes since then, though they were pre-filed?
I'd like to make an update and potential clarification regarding short-term debt. On page 8, lines 1 through 4, I explain the average monthly short-term debt interest rate for the period of February through June, and I want to make sure it's very clear that that is an on average monthly annualized short-term interest rate. So in order to do so, I would insert on line 2, I would insert annual between monthly and short term, which goes to the next line, and then to make sure it is absolutely clear what that would convert to as a monthly interest rate, I would like to at the end of the sentence on line 4 indicate quote, this converts to monthly rates of 0.03%, 0.03%, 0.02%, 0.02%, and 0.02%, comma, respectively.
And with those revisions are Exhibits 206 and 207 your testimony here today?
Yes.
I offer Exhibits 206 and 207 as modified by, or with the addition, well, I just offer the exhibits.
Exhibits 206 and 207 have been offered. Any objections to their receipt? Hearing none, they will be received.
I tender the witness for examination by others.
Thank you. And for cross, we begin with staff.
Thank you, Judge. Mr. Murray, can you turn to page 9 of your rebuttal testimony?
Yes.
That's where you talk about the net present value discount rate.
Yes.
Then on page I apologize. There's a portion of your rebuttal where you mention the all-in cost.
Yes.
Can you clarify what you mean by all-in?
What I meant by all-in was determining what the net proceeds were to the company, subtracting the issuance expense. So more or less, that's the same thing as commonly is understood as an embedded cost of debt, because the company will have to pay, the issuance expense. That is factored in in determining an all-in rate.
Okay, and you mentioned embedded cost of debt. Can you define that?
Embedded cost means it's once it's issued and the net proceeds and the interest expenses applied on a present value, future value basis, that determines the cost as of that time of issuance.
Thank you. Now on page 12, at line 2. It appears you used the 2.47% rate as the discount rate to calculate the net present value estimate.
Yes.
Did you apply that to both the net present value of traditional financing and securitization financing?
No,
Okay. What did you use the 2.47% to discount?
just for securitization financing.
Okay. What percentage rate did you use for traditional financing?
I think I used a variety of discount rates for, to test what the net present value estimates would be. And the main rate I used was and it's highly confidential, so I won't indicate what the exact rate is, but was a weighted average cost of capital determined by LUCO for purposes of assessing the fair value of its assets for goodwill impairment.
Okay, so for the traditional method of financing, you used a discount rate approximately the weighted average cost of capital.
Based on current cost. The problem I have with if you don't mind if I explain, the problem I have with the historical rate of return is that's based on a rate of return, an estimated cost of capital back in 2019. I wanted to look at how the company was estimating the present value of its anticipated cash flows going forward as recently as possible.
Okay. And then you also mentioned earlier, though, that the 2.47% you don't believe indicates like a currently accurate estimated securitization rate.
But I think, if you don't mind if I explain, if the easiest way to make my position clear is the securitization rate at the time of issuance, which will be determined, after this, whenever we're getting ready to go to market. That is the appropriate discount rate to apply to payments under the securitization of the whatever the costs end up being, because it's just like issuing a bond, and so the rate charged on the securitized bond is the risk of those cash flows, and so that it should be whatever that is at the time.
Okay. Now, you agree that the interest rate that will be applied to that would be applied to securitization in the future, we don't know exactly what that is, right?
Yes.
The best we can do is estimate it right now.
Yes.
And based on current estimates, do you believe it would be 2.47%?
No.
Do you believe it would be higher?
Yes.
Okay. Now, assuming that securitization bonds are going to have a lower interest rate than a company's approximate weighted average cost of capital, is that a safe assumption?
Yes.
So using a weighted average cost of capital as a discount rate for traditional financing and a securitization interest rate as the discount rate for securitization financing, would that calculation ever yield a net present value benefit for customers from securitization?
It depends on what you're using for weighted average cost of capital. So I don't know the answer. There's too many hypotheticals. I'm sorry.
Okay. No further cross.
All right. For Renew Missouri,
No questions, Your Honor. Thank you.
for Liberty,
Yes, Your Honor. Mr. Murray, I think you say in your testimony, and maybe this is linked to Mr. Stokes' question, but then again, maybe I didn't follow his question, similar to you. But in your testimony on page 2, you indicate that if the commission views traditional and customary methods of financing to allow a rate of return inclusive of an ROE, securitization will be less costly to ratepayers, correct?
And I'm referring to what the commission authorized with the rate of return. So yes, I mean, it's not updated. So yeah, I'm following along with what some of the assumptions are used by other parties, specifically your witness and direct testimony.
Right. And how about this statement? Would you agree with this? This is from Ms. Niehause's rebuttal. While the pricing of AAA bonds will increase with general market volatility, pricing of traditional methods of financing will as well. Meaning if we see the price of the AAA bonds going up other types of financing will likely follow. Would you agree with that?
By the same issuer. I mean, that's a very broad, but typically by the same issuer with the same terms and, tenors and what have you. There's a lot of assumptions there, but generally, yes.
Generally, yes, correct.
Yes.
Now, I understand you recommend no carrying costs for Asbury, correct?
Yes.
And as I read your testimony, that's based on OPC's position in the 2021 rate case, correct?
Yes.
And not based upon any particular reading of the securitization statute itself. You're not making an argument that the securitization statute will not allow carrying costs, correct?
I'm not interpreting the statute.
Yeah. You're making no representation as to the statute at all, correct?
I would say that I put in quotations customary and traditional, and I notice there's discrepancies within the statute, and then I notice that they're not defined in the statute. So, and from that layman's perspective, I consider that definition to be up in the air.
But that's all you were focused on was just those terms, correct? Customary and traditional.
I do not know that statute backwards and forwards. I looked at the first 3-4 pages, which really, get to the crux of estimating a securitization amount.
That's all the questions I have here.
All right. We'll come up for questions from the bench. Are there any questions from the commissioners on the line?
Judge, this is Commissioner Sylvia. I have no questions at this time.
Thank you.
Judge, this is Commissioner Holzman. I also have no questions at this time.
Thank you. I do have some questions. First of all, what's the time frame for which your 4.65% WACC weighted average cost of capital was calculated?
I'm sorry, I don't think I calculated a 4.65%. I think that might be the staff's recommended cost of long-term debt.
Okay. What was your weighted average cost of capital?
I used we would probably need to go into, because I used a internal document
Okay.
for purposes of their goodwill analysis.
You don't need, that's in your rebuttal testimony, I'm assuming.
Yes, it is.
Okay, you don't need to repeat it here then. And what time frame was that?
It was 2020 is the latest update I received. They've updated since then, but I do not have a copy of that.
Okay.
The company has.
In your calculations submitted on June 9th, you included financing costs for the traditional financing scenario. Please explain why you did this, given that other parties did not include financing costs for the traditional financing scenario.
I'm sorry, I'm confused by that question. I'm not following.
Okay, I'll repeat it. You included financing costs for the traditional financing scenario. Is that correct?
I included financing costs for the carrying cost. So I did not include anything other than for the carrying cost.
Okay, why did you do that?
I did that because, Storm Uri, it's a much bigger issue because it's from February 2021 through the estimated time of issuance of the bonds, which may be December 2022. And I provided the cost of short-term debt because that's how they funded. And actually that is, in my opinion, customary to how you would fund a working capital need. So that's why I included the cost of short-term debt, which was very low until recently, and so that's why those rates seem very low. It may have been assumed by some to be a mistake, but the cost of short-term debt on an annualized basis was 0.25%, and so I used that to provide information to the commission as to, similar to AFUDC, that since I did not include that in my capital structure in the general rate case, that should be captured somewhere in the rate making that's considered by for Empire's rates charged as ratepayers.
Okay. And in your NPV comparison calculations, you use different discount rates for the securitization and traditional financing NPV calculations. Can you explain why?
This is a situation that I feel, don't just feel strong about, but I think it's a very fundamental concept of finance that just like when you issue, if I bought a bond today at 4.5%, I am going to receive 4.5% coupon payments. And so the appropriate discount rate is the expected cost of financing because I am going to receive an annuity. And the whole purpose of securitization is to achieve the highest credit rating possible and fund this by all debt and provide the proceeds to the company. And then you have this true-up process where it's a separate line item. The assurance of payment to the company is when I say the company, the special purpose entity is to make sure that there's very little to no risk on this issuance through this process. So the risk using a rate of return assumes an overall corporate cash flow, and so that's why a weighted average cost of capital, which you would hope would be synonymous with rate of return, would make sense in that situation. But with securitization, the whole purpose is to make these payments literally almost no risk. And so that's why it's just like I said, it's just like buying a bond today. The principal amount would be the present value because your expected interest rate is what you're buying your bond for today.
Okay. And that's all the questions I have. Are there any questions based on those questions from the bench or any recross staff?
No, Your Honor.
Reno, Missouri?
No, Your Honor.
No questions, Your Honor.
All right. Then redirect.
Thank you. I think just a few. You recall when staff was asking you about this is Nathan Williams, by the way, asking you about the discount rates, the MPV versus securitization and traditional rate making?
Yes.
And you indicated that you looked at goodwill impairment, and you based it on a confidential company document?
Yes.
And you also mentioned LUCO in your response. Would you explain why you were looking at LUCO?
LUCO is the main holding company for all the U.S. regulated utility assets. When I say holding company, it's an indirect holding company. They have a Liberty Utilities Central is the immediate holding company, but LUCO handles all their corporate. When I say LUCO, the company holds all the corporate financing activities that through a financing subsidiary named Liberty Utility Finance Company, I believe. And so, but they are responsible for all the accounting and financial performance and I guess reporting of how their regulated utility assets in the United States are doing.
And then in response to a question from staff counsel, you indicated that you believe that by the time of issuance, the securitization rate will be greater than 2.47. Would you explain why you believe that?
It's based on the current interest rates. I'm not going to claim to be a market prognosticator. Current interest rates are, in my opinion, the best predictor of future interest rates. That's what's embedded in the current market. And, obviously we have a lot of things going on in the market right now with concern about inflation and the Fed just increasing the Fed funds rate by 75 basis points yesterday.
No further questions. Thank you.
Thank you.
All right, then, Mr. Murray, you can step down.
Thank you.
May be excused.
Yes.
Thank you.
And I believe the next witness is in is Frank Graves for Liberty. Good morning.
Good morning.
Please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth.
I do.
Thank you. You may inquire.
If you'll please state your full name.
Yes, Frank, middle initial C, last name Graves, Graves.
How are you employed and in what capacity?
I am what we call a principal, which is essentially a partner in a consulting firm called the Brattle Group, Brattle, with headquarters in Boston, Massachusetts.
And did you have cause to prepare, did you prepare and have cause to be pre-filed in this case testimony on behalf of the Empire District Electric Company?
Correct.
And that was both direct testimony and surrebuttal testimony?
That is correct.
And have those documents been marked as Exhibits 16 and 17?
Subject to check, I believe that's right.
Do you have any changes for that pre-filed testimony?
I do not.
If I asked you those same questions today, would your answers be substantially the same?
Yes, they would.
And are those answers true and correct to the best of your information, knowledge, and belief?
Certainly.
I would move for the admission of Exhibits 16 and 17 and tender Mr. Graves for cross-examination.
Thank you. 16 and 17 have been offered. Any objection to the receipt? Hearing none, they will be received. For cross-examination, we begin with Renew Missouri.
No questions, Your Honor. Thank you.
For staff.
Thank you, Your Honor. Kurt Stokes on behalf of staff. Mr. Graves, how much are you being paid to testify today?
My billing rate is $725 an hour.
Thank you. Liberty's asking ratepayers to pay for all of Asbury's remaining costs, correct?
It's unrecovered net costs, that's true, yes.
Those full unrecovered costs would be the same rates that Liberty ratepayers would pay as if Asbury were in service and providing electricity, correct?
I don't think that's quite correct. If the arrangement is that the unrecovered costs will be securitized, it will be paid by customers at a lower rate than it would have otherwise been paid, or and on a different schedule.
Okay, so, but other than the timing and interest rate differences, Liberty's seeking full recovery of all Asbury costs.
That is correct.
Now, Asbury did not provide electricity to customers during Winter Storm Uri, is that correct?
That's my understanding.
And Asbury will never again provide electricity to Liberty customers, is that correct?
As far as I know, there's no plan for any future recovery, so yes, I agree with that.
And so Liberty really is not seeking any sort of cost sharing of Asbury's retirement with ratepayers.
I'm not sure how that's related to the previous question, but there is an embedded cost sharing by virtue of the fact that Asbury has been providing lots of benefits for which ratepayers didn't have to pay any of the advantages, they just paid the costs. Now it's not as economical as it used to be, and it's better to replace. But since there was no gain sharing in the past, there should be no loss sharing now. In my view, there's already been the right amount of sharing.
You are not suggesting that the commission reject the used and useful standard, correct?
I think it can be used, but it's a very blunt instrument that basically only tells you if the asset is performing. Pretty much that's it. It doesn't tell you about the economic drivers of its situation, causes, responsibility, what's replacing it and whether that's more valuable or not. So it's a starting point for wondering how much cost recovery should be allowed and in what form, but it's not informative by itself.
Okay, but the commission should not reject that principle entirely.
Only if it's the only principle they're going to use, then I would reject it in its entirety.
No further cross.
Okay. And public counsel?
Nathan Williams, no questions, thank you.
All right. Come up for questions from the bench then. Commissioners on the line, do you have any questions?
No questions, Judge. Commissioner Holton.
Thank you. And I have no questions, so no need for recross. Any redirect?
No, Judge, thank you.
Then, Ms. Graves, you can step down.
All righty, thank you much.
And I believe the next witness then is Katrina Niehaus.
Judge, I'm waiting for a document that one of our folks was supposed to bring back from my office. Could you give me about 5 minutes to locate where that is
Before this witness testifies?
before this witness testifies?
Yes, we can do that.
Okay, thank you. I apologize, Your Honor.
All right, we'll take a 5-minute break. That would bring us back at, well, 9:01, so. Thank you. don't think I've sworn you in yet, have I?
You have not.
All right. Please raise your right hand. Solemnly swear or affirm testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth.
Yes, sir.
Thank you. You may inquire.
Thank you, Your Honor. Would you please state your name?
Katrina Niehaus,
By whom are you employed and in what capacity?
Goldman Sachs, and I run part of our structured finance business there.
Are you appearing today on behalf of the Empire District Electric Company, which does business as Liberty?
Yes.
Have you caused to be prepared for the purposes of this proceeding certain direct testimony for both cases EO-2022-0040 and for EO-2022-0193?
Yes.
And then you also have prepared surrebuttal testimony that was filed in both cases, correct?
Yes.
Is it your understanding that that those pieces of testimony have been marked as exhibits 18, 19, and 20 for identification?
Yes.
Do you have any changes that you would like to make to that testimony?
Not at this time.
If I ask you the questions which are contained in exhibits 18, 19, and 20 today, would your answers be the same?
I think the only difference would be obviously markets are continuing to move, and so rates on the securitization would be in a different place today than they would be in the future.
And with that, that caveat, are your answers true and correct to the best of your information, knowledge, and belief?
Yes.
Your Honor, at this time, I would offer exhibits 18, 19, and 20 into evidence.
Okay, 18, 19, and 20 have been offered. Any objections to their receipt? Hearing none, they will be received. And for cross-examination, we begin.
Judge, I'd like to go ahead and mark the other document that I had referred
Okay.
to previously, if we could do that.
Sure.
And I
Next
believe
number
we're
is
up to
24.
24, yes. Do you recognize what has been marked as Exhibit 24?
Yes.
And is that a document that was prepared by you or at your direction?
Yes.
And is that a document that would be of assistance to you in answering questions 1 through 3 of the Notice of Commission questions that was issued on, let's see, I think June 9th?
Yes.
Judge, I think we'll leave it there for the time being.
All right.
And we would tender Ms. Niehaus for cross-examination.
Very good. Then we will begin for cross-examination with Renew Missouri.
No questions, Your Honor. Thank you.
For staff?
Thank you, Your Honor. Kurt Stokes on behalf of staff. Ms. Niehaus, were you listening to the testimony of Mr. Mosendy yesterday morning?
I was not.
Oh, okay. Is it your understanding that there is usually an informal process that takes place to review an issuance advice letter where everybody involved goes around and ensures that they're all on board with that?
Yes, we would welcome that input.
Okay. How far in advance of that issuance advice letter does that process usually take place?
Generally, that would happen in the few weeks leading up to a transaction
Okay.
pricing.
And does not doing that in advance or along the way create potential for a delay?
Yes, our goal would be that everyone has agreed to the contents of the issuance advice letter in advance of bringing a transaction to market. We wouldn't want to have any disagreements during the marketing or pricing process.
Okay. Now, in your direct testimony, that was filed in January of this year, correct?
Yes, that sounds right.
And you referenced at that time, an expected weighted average bond interest rate of 2.47%.
Yes.
I believe you said on direct that, the markets are continuing to change.
Yes.
So I hope I'm not putting you on the spot too much. If you refreshed that testimony to reflect an expected weighted average interest rate based on current market conditions, what would that rate be today?
So we have, in this newest exhibit, submitted pricing as of Friday. Obviously, I was traveling yesterday evening and so have not updated my pricing as of this morning. And there has been significant market movement with the FOMC announcement yesterday, as well as where futures are today and Treasury rate movements. As of the pricing as of Friday for a blended securitization, it would be around 4.28%. What I would note is that is as of Friday. Markets are evolving, and we would expect to adjust our pricing and structure thoughts in conjunction with the market to get to the best outcome for the ratepayers of Missouri.
Okay. Can you state how that at the rate as of Friday, the 4.28%? Can you kind of walk us through how that rate was derived?
Sure. So there's generally two components to how investors think about the interest rate they should receive on bonds. One is the base rate or the risk-free rate. That would be the Treasury reference. And then the second would be the risk premium. That would be the spread to Treasuries that's outlined in my materials. And so both of those move in conjunction with market sentiment. Treasury rates is something that is definable and knowable based on where you can see Treasury rates trading. The credit spread is something that we will discover during a marketing process. This is our best estimate as to where credit spreads are today based on where other comparable transactions are pricing and trading in the secondary market.
Okay. You said, based on other transactions, how many securitizations have been issued since January of 2022?
I would have to get back to you on that. When you talk about utility securitizations, which would be the most relevant comparison, there are a handful, though not all of them look like your transaction. So I think it's probably been 4 or so, but we can come back with the exact number. Then as far as transactions as a whole, it would be a number. Actually, I do actually have the count here. I can count 1, 2, 3, 4, 5, 6, 7. So since January 2022, there have been 7 securitizations.
Okay. And is that
Utility securitizations.
Is that from Appendix A of what has been marked as Exhibit 24?
Yes.
Okay. That's what you were counting.
Yeah.
This kind of goes to what has been marked as Exhibit 24. Would the rate be different for Uri and Asbury securitizations if they were separated?
Our current expectation is the rate would be different. When investors assign that risk premium, one of the things that is important to them is liquidity in the securitizations. The Asbury securitization is a bit smaller than the Uri securitization, and so as such, a investor may require more of a risk premium because there would be less liquidity in those bonds, and it may be more difficult for them to exit out of their investment in the future.
Okay. Another putting you on the spot question. How would you expect the interest rate to change between now and the anticipated date of issuance?
I wish I knew that. I don't know that I'd be sitting here if I could tell you. I do not have a crystal ball. It is hard for me to say what direction things will move in. There are obviously macroeconomic events that can cause significant changes to the market environment. Sitting in my seat in January when we filed our original testimony, we were in a very different place. I don't think people did not envision the Russia-Ukraine situation unfolding in the capacity that it did, and so events like that can create material changes to the market for the positive and for the negative, and so I wouldn't feel comfortable projecting what's going to happen with rates going forward.
Now, assume that the commission issues a financing order and the issuance of bonds is delayed by an appeal by about 12 months. What would you expect the effect on the interest rate change to be if that were to happen? If you know.
That is unknowable.
And then I think getting into, and if you want to refer to Exhibit 24, please do. Can you summarize the benefits and downsides of combining the winter storm and Uri and the Asbury securitizations?
Sure. So as we think about the benefits to combining the transactions, I think there are a couple. First is we would expect the upfront transaction costs for a combined transaction to be less than the sum of two separate transactions. There are certain transaction costs that scale based on size, but there are a number of costs that are fixed costs. So by issuing a single transaction as opposed to two separate transactions, you would reduce the occurrence of those fixed costs to a single cost. The second is we would expect that a larger transaction would have more liquidity in it, and as I described, it would be more desirable to investors, and therefore should result in a lower interest rate, which would ultimately be passed forward and through to the ratepayers in Missouri.
Okay. Now, as far as downsides or risks of issuing a single financing order and a single bond issuance, would exposure to interest rate volatility be one of those potential risks?
A single transaction, so
I guess I withdraw that question, Your Honor. So let's premise my question on the idea that if the commission issued one order in one case that was not appealed, and an order in a separate case that was appealed, and that allowed Liberty to move forward quickly with one of the securitizations, but not the other, compared to a situation where the commission issues one financing order and everything is held up by an appeal. Would exposure to interest rate volatility for the one that would not have been appealed, would that be a...
that would be a consideration.
Okay.
Yes.
And there's probably no way to actually calculate and quantify that, correct?
I am not able to project what will happen in the markets.
Is it possible that interest rates could reach a level where there would no longer be a quantifiable net present value benefit from securitization?
If you look at historical utility cost of capital as compared to current interest rates, there could theoretically be a point where that occurred. But in general, as interest rates increase for the securitization, one would expect that the utilities cost of capital would also increase, given they're both referencing similar investor bases and tied to the same sort of treasury base rate calculation.
Okay. You had mentioned spread earlier. Can you explain what spread is?
Yes. So when investors think about deploying their capital, they look at the risk-free premium, which is the treasury rate, and then a spread, which is what they demand in return for the risk of a particular transaction. For example, generally, a AAA rated securitization would have a lower spread than a single A rated securitization because the risk associated with repayment is lower in a AAA securitization than in a or a single A securitization.
And would the AAA securitization be a proxy or a comparison point for a utility securitization like Liberty is seeking in this case?
Yes.
And the single A would be a proxy or approximate comparison for like traditional financing by a utility?
Not necessarily. I'm just saying, in general, for when investors are looking at securitizations broadly, utility securitizations have historically been rated AAA, but there are many other kinds of securitizations, some which do not have AAA ratings. There would be other appropriate comparisons for the utilities cost of debt and equity.
Okay. Do you know the level of the interest rate on securitization would have to hit before there would no longer be a quantifiable net present value benefit?
Well, if the securitization cost of capital exceeded the cost of the utilities blended cost of debt and equity, there would not be a perceivable NPV savings unless the utilities cost of debt and equity was reset to then current market rates.
But in that net present value benefit calculation, you also have to take into account financing costs, correct?
Correct.
So it would be not necessarily exceeding the utilities' cost of capital. It would be something slightly lower.
Sure,
Depending,
yes,
depending
something
on the,
slightly lower.
and it would depend on maybe the size of the security.
The size of the securitization, the magnitude of the financing cost, and the duration of the securitization.
Okay. Let's switch gears to the proposed certificate to be filed by Liberty Utilities. Liberty does propose that a certificate be filed with the commission by the underwriters. Is that correct?
Yes.
And can you tell me what the underwriters do?
So the structuring advisor and underwriters do a number of different things. First, we work with the utility to structure a transaction that is desirable to the market. We will help guide the utility through their rating agency process to achieve the highest possible rating, which ultimately will result in the lowest cost of capital. We will work with the utility and their lawyers to create appropriate disclosure and marketing materials. And we will work to market the bonds through our sales force to a variety of investors and guide the utility and their commission and advisors through the marketing and pricing process.
Okay. So there's a lot of coordination, it sounds like. Is there something called like a syndicate team?
Yes, our syndicate desk is a group of individuals who would be guiding the transaction through the ultimate marketing, pricing, and the marketing and pricing of the transaction.
Okay. You were also proposing that Liberty itself file a certificate with the commission, correct?
That is my understanding, yes.
Now, that certificate states that there are quantifiable net present value benefits with the bonds as structured.
Correct.
Are there qualifications or disclaimers on such a certificate?
I wouldn't be able to comment on the details of Liberty's certificate.
Okay. Now, what about on the underwriter certificate? Are there qualifications or disclaimers?
Yes, the underwriter certificates do generally have qualifications and disclaimers around achieving best pricing at the time based on the current market environment. And those qualifications are relatively standard across utility securitizations.
Is there a copy of such a certificate attached to the proposed order in this case?
We have not filed a draft of our certificate yet, I don't believe.
I believe your testimony references a draft issuance advice letter being circulated before the actual issuance advice letter.
Yes.
Would a draft of those certificates also be circulated?
Generally, we would circulate that in advance as well.
Okay. Now, do the underwriters have any fiduciary responsibility to Liberty Utility ratepayers?
No,
Does Liberty have any fiduciary duty to its ratepayers?
I wouldn't be able to comment on that.
What would it cost Liberty to finance your costs absent securitization?
I assume they would be financing them at their blended weighted average cost of capital, so debt and equity.
Okay. And do you know that what the cost of that is today or recently?
I believe it was in the 6% area, but I don't know the exact number.
Have you read staff rebuttal testimony by Sarah Lange proposing cost allocations to all customer classes based on an energy allocator?
Yes.
And would you anticipate that such an allocation would have any adverse impacts on the bond issuance?
There are a lot of components that go into creating the tightest structure possible. The allocation of costs is something that is more of a political discussion than a ratings discussion. So I wouldn't want to comment on the fairness of her proposal. And so what we would do is work with, once we have a proposal for how costs should be allocated, work to make sure that there are appropriate true-up mechanisms between classes, so that in the case of the securitization, there aren't any shortfalls that would result in a shortfall of bond payments. But commenting on the appropriateness of allocations is generally not something I would do.
Okay. Assuming the commission agreed with staff's position that if a customer in one class moved to another class, that the kilowatt hours associated with that customer moves with the customer, and that the energy allocation kind of takes care of itself without having to over or under recover from different classes. With that understanding, would you believe that that would be a lower risk cost allocation and true-up mechanism?
We have worked through a number of different allocation mechanisms. I wouldn't necessarily say that one is lower risk or not. It's more assuring that the document appropriately reflects the mathematical accuracy of how the calculation is going to work, and that there is never a case where you are not able to true up for a customer movement.
Okay, and so segueing into that true-up mechanism, does Liberty agree that the mandatory true-ups at least every 6 months with an interim optional true-up, is that ideal?
I can't comment on what Liberty would say, but what I can say is that would be standard for utility securitizations, and would allow us to comply with rating agency criteria to achieve the AAA rating, putting aside any other impairments to the structure.
Okay. Now, you had mentioned one benefit of a consolidated offering is avoiding duplicative financing costs, correct?
Yes.
So I'm guessing that to date, Liberty has not incurred any duplicative costs.
I do not believe so, but you would have to check with Liberty to confirm that.
At least with Goldman Sachs, they haven't.
They have not.
Now, you can agree that it's important for the staff, for a staff designated representative and financial advisor to be able to provide the commission guidance on the issuance advice letter, correct?
Yes, we would welcome your input.
Okay. And to be able to provide that guidance, you agree that the commission would have to provide input and collaborate in all facets, correct?
I think there is specific language around the commission and their advisors' involvement in the transaction. I am not one who is in a position to comment on the appropriateness of that. I have worked in many different states where there are different involvements from the commission and their financial advisor in the process, and I follow the rules and guidance of the legislation and the commission and adhere to the policy that's set for me.
Okay. How much is Goldman Sachs being paid as part of this securitization case?
So we would hope eventually to be an underwriter. I think and then we are receiving a structuring fee of, what are we getting here? $255,000, I believe.
Okay. And are you being paid as an expert witness?
No.
In this fee? Okay. No further questions, Your Honor.
All right, for public counsel.
Thank you. Nathan Williams, Public Counsel. Good morning.
Good morning.
I'm going to start with what Mr. Cooper's probably hoping someone does. On Exhibit 24, there are a number of things in there that are not clear to me as to exactly what they mean. So
Sure.
my questions are starting off will be about clarification.
Of
So
course.
if you turn to Exhibit 24, In the line that talks about liquidity and offering, there's a reference to a minimum size of, I'm not sure what that symbol is, but 250 plus, and then MM. What is that saying? In English, what does that say? Or verbally?
Yes, so I would say generally investors, when they consider a liquid securitization, would look to see a transaction that is around 250 million, so approximately 250 million in size, for a minimum transaction size to be viewed as liquid. Below that, investors will view it as a smaller transaction, and you may have impacts on pricing and liquidity.
So if I see MM throughout this document and with reference to monetary, it means millions.
Yes, sir.
And then there's a line estimated upfront financing costs, and then there's in parenthetical from Hunton. What is Hunton?
Hunton is the law firm who is representing Liberty in this transaction.
And I assume TBD means to be determined?
That is correct.
And then over on the second page where you have a table, there are classes and there are some letters.
Yes.
What is WAL referring to?
It refers to weighted average life, and so that is the average period of time in which principal is repaid for a particular class of bonds. When investors look to reference...
Oh, that's good enough. Yep. I'm just looking for what the letters mean. TSY tenor, what does that mean?
The treasury tenor that we are reflecting from the pricing perspective.
And TSY spread?
That would be the spread to the treasury rate.
Spread between what?
That would be the risk, as I mentioned, when an investor prices a bond, they look for the risk-free rate, which is the treasury rate, plus a risk premium of the spread. So that would be the spread to the treasury rate that gets to your all-in interest cost.
What does principal window mean? Or I assume PRIN window is principal window?
It is the period of time in which principal is repaid to investors. So you'll note in the Class A1, principal is repaid to investors starting on the first payment date, which would be slightly after issuance, which would be year 0 through year 9. For the URI securitization, Class A2, principal is returned to investors between years 9 and 13.
Thank you. EXP final?
That would be the expected final maturity of the bonds. And so you can see that would be the last date that principal would be expected to be repaid to investors.
And then following the word Asbury, you have 10 BPS wider. Are those basis points?
That is basis points. So that's a note that due to the liquidity
and basis points is how much of a percent?
1 basis point is equal to 1/100th of a percent. So Asbury would price approximately 10
Thank
basis
you.
points
You've answered
wider.
my question. Are the revenues that bondholders receive from these securitization bonds, if they're issued in this case, or the bonds that are the subject of this case, would those be subject to federal or state income tax?
Yes, these would be taxable bonds.
No further questions, thank you.
All right, then we'll come up for questions from the bench. Any questions from the commissioners online?
Thank you, Judge. This is Commissioner Sylvia. I have a question.
Go ahead.
Thank you. You were asked a question about duplicative financing costs if the commission were to issue 2 orders instead of 1.
Yes.
Could you provide some sort of ballpark or range on what duplicative costs may be if the commission decides to issue 2 orders instead of 1?
Yes, so I think there are a number of costs that we are not a party to negotiating, like the commission's own advisory costs, which I assume would be less in a single transaction than if you were to issue 2 transactions. But I think we believe that it would save based on what we've submitted for Exhibit 24, somewhere in the order of magnitude around a little over $1 million, so somewhere between $1 million and $1.3 million, if I'm doing the math right on the spot, but someone should check that. And we did submit the exhibit that shows the differential.
Okay, so your estimate is between $1 and $1.3 million in duplicative costs if we were to issue 2 orders instead of 1.
That's correct.
Is that accurate?
That is my estimate,
Okay.
based on our knowledge as of today.
Okay, thank you, Judge. No further questions.
All right, and I do have some additional questions, and I'll start out by saying that my initial questions about combining costs have been pretty much answered with your Exhibit 24, so I won't go into that. But some more general questions. How have interest rates changed from 2018 to current? Have they generally increased or decreased, and by how much?
Generally increased. I would have to go back and look at what Treasury rates were in 2018, but there has been a general increase.
Okay, and there's even more volatility in the last few months?
Yes, including last night.
Okay. Can you please explain your role as financial advisor to Liberty?
My goal is to help them appropriately prepare and file for this transaction, get to the point where we have a serviceable financing order and begin the preparatory work for a rating agency process, and provide guidance on transaction structure and what might be best received by the market.
And I assume Goldman Sachs has experience in this role?
Yes, sir.
Does Goldman Sachs also have experience as an underwriter?
Yes, sir.
And will Goldman Sachs be the underwriter for this transaction?
I hope so, but I suspect there will be a selection process that we will be a part of.
Okay. And is that up to Liberty to decide who's going to be the underwriter?
That is my understanding.
Okay. If you were to be the underwriter, does that create any potential conflicts of interest in performing the 2 roles as advisor and as underwriter?
I do not believe so. It is standard practice for the financial advisor to also be the underwriter, and in the majority of transactions, the financial advisor is best positioned to be the underwriter and able to actually create efficiencies in process by having continuity of advice to the utility.
Okay. Can you explain the difference between Rule 144A Reg A bonds versus bonds registered with the SEC?
Well, I'm not a lawyer, but Rule 144A bonds are a form of private placement that do not require registration with the SEC or as much government regulatory oversight. In general, there may be slightly more upfront costs with an SEC-registered transaction because you do have to file with the SEC and prepare compliant documentation. That said, SEC-registered deals generally are more liquid than Rule 144A deals and perceived by the market in a favorable fashion, which would ultimately result in a lower interest cost and a savings for ratepayers.
Okay. It's my understanding that Liberty's planning on issuing bonds registered with the SEC. Is that still the plan?
That is my expectation as well.
Okay. Are there any conditions under which Liberty should consider issuing the Rule 144A bonds?
The majority of the transactions that have been issued in the utility space have been SEC registered because the goal is to achieve the lowest cost possible. To the extent you did not issue SEC registered bonds, I would expect certifications would have qualifications around that point.
Now, this next question is about bond marketing and pricing process generally. Does the Commission's decision to issue a single financing order or 2 affect either positively or negatively the ability of Liberty and the underwriters to successfully market, price, and issue a combined bond offering?
We expect to be able to successfully issue bonds regardless of the framework for a single offering or 2.
Okay. What effect, if any, would the appeal to a court of the commission's financing order have on the underwriter's ability to proceed with the bond issuance process?
We are not able to proceed with the bond issuance until the financing order is final and non-appealable.
Okay. Would a single, I think we kind of got into this with staff's questioning, but if the commission were to issue two separate financing orders and only one of them were appealed, would that provide any benefits?
I think what you're asking is, maybe I can frame the question to make sure I'm answering appropriately. A delay caused by the appeal in a financing order would delay the transaction. We do not have the ability to foresee what will happen with markets over time. So by taking risk off the table for a single issuance, let's say one of the orders was not appealed, I think as a statement was made earlier, you are taking less market risk through that process, though in return, we expect there may be more upfront financing costs and less efficiency in execution for the second smaller transaction.
Okay. What would happen if, in the process of, after the commission has issued its financing order, before the bond can be priced and so forth, what would happen if the market were to change such that there would no longer be a benefit for the financing as you described earlier with?
I presume there would be some pretty serious discussions about whether to proceed with the transaction.
Okay. So would the commission have any say in any more as to whether that transaction would proceed?
I am not a lawyer, but my understanding is that Liberty in their certification does need to show savings. And
Okay.
so if they were unable to show savings, I assume there would need to be further discussion about how to proceed.
Okay. Now, what's the minimum dollar value of securitized property at which a reasonable underwriter would expect sufficient investor interest, liquidity, and AAA bond rating such that the bonds are issued at the lowest available cost for Liberty's customers?
So as I mentioned, 250 million is the rule of thumb, though we have done securitizations that are much smaller, and our goal is always to get the best execution for the ratepayers based on the framework that we are living within. If we end up moving forward with two separate transactions, we would do our best to get best execute, assuming we were the underwriter, we would do our best to get best execution for both transactions based on the facts and circumstances of those particular transactions.
Okay. So if, for example, you had a bond issue of 150 million instead of the 250,
I would expect less focus from investors.
okay, would that imply a higher interest rate?
Yes.
And yeah, how much?
In the filings in Exhibit 24, we imply that it would be approximately 10 basis points based on our best estimates in today's market.
Okay, and so if it was a $75 million issuance, it would be something higher interest again?
That level of precision is challenging to
I'm not
articulate, but yes.
Okay. How much of the estimated financing costs proposed in Liberty's petition is fixed versus variable costs?
I don't have that off of the top of my head. There are certain costs that are fixed, like legal fees, trustee fees, etc. There are certain costs that are variable, like, and related to transaction size, like rating agency fees, underwriting fees, and SEC registration fees. I have not done the breakout for you, though.
Okay, and just looking at Exhibit 24, there's a listing of various financing costs. Would the to be determined amounts, would that tend to be the ones that are variable?
No, I think we just didn't have certain amounts. So for example, we have the commission's financial advisory fees as to be determined. Those are generally not variable based on transaction size, but we have not been provided with that information.
I see. Thank you. Now, I have some questions about the post-financing order process. Should the commission require that a bond advisory body be established consisting of Liberty, the commission staff, and any designated staff or consultant advisor to Liberty, the commission, and and the Public Service Commission staff, basically a bond advisory team? Is that something that you would suggest or oppose, or?
I follow the rules as they are outlined to me, and so I don't feel that it's appropriate for me to comment on that.
Okay.
I am excited to work with the commission and their team in the capacity as determined that's appropriate.
So you'll work with whatever you're told to work with?
Correct. That's what you pay me for.
Okay. What will be the parameters of the bonds establishing the terms and conditions of the bonds, including but not limited to repayment schedules, expected interest rates, and financing costs?
What would be the parameters?
Yes.
So my understanding is the recovery period for these bonds is 13 years. We are targeting level debt service, and so those are the two main parameters. We would then, upfront costs are going to be what they will be, and we will create a structure that is appropriate based on market demand at the time of issuance. But the two main parameters that I believe you're asking to be set are the expected final payment date, which I believe is something like 13 years, and the shape of the debt service schedule, which my understanding is a level debt service schedule.
Should a procedure be established that allows or requires the staff to audit the ongoing financial costs post-issuance of the bonds?
Generally, in order to achieve a AAA rating, a review of, are you talking about the true-up mechanism?
Yes.
The only input that can be had on the true-up mechanism by the commission is to check the mathematical accuracy of the calculation.
And that's established by the statute?
Yes.
Do traditional financing methods incur financing costs also?
Traditional being a investment grade utility offering?
Yes.
Yes.
And what kind of costs would those be?
I do not do investment grade utility bond offerings. It is something I could come back on, but there would generally be legal fees. If you need an order of magnitude, I cannot comment on that, but I would expect the costs to be in similar categories, including legal expenses, rating agency fees, as well as underwriting fees.
Why weren't financing costs included in Liberty's traditional financing MPV scenario, if you know?
I can't comment on that.
Okay. You weren't involved in
No.
creating that. Based on your bond experience, are these activities part of the process to undertaken by the utility or issuer to place bonds on the market? First of all, selection of the underwriters, is that part of the process?
Underwriters must be selected in order to proceed with a bond offering. The process around selection of the underwriters, it would be a conflict for me to comment on, given I hope to be an underwriter.
Okay. How about preparing for and registering the bonds with the SEC?
Are you asking if that would be a
Part of the process?
part? Yes. The underwriter, once underwriters were selected, generally they would help to prepare offering documents and register the bonds with the SEC in conjunction with the utility and their counsel.
Okay. And preparing for and meeting with rating agencies?
Yes.
Preparing for and marketing the bonds?
The underwriters would be involved in preparing and marketing the bonds, yes.
Are there any other activities that are part of the process?
There's preparation of other ancillary materials, so investor presentations, cash flow analysis, marketing calls, preparation of a model and cash flows for the rating agencies. There is a number of other steps that go into the preparation of these transactions.
Okay. Does issuing two financing orders require two separate bond issuances, or can one transaction be created from two financing orders, one for Uri and one for Asbury?
It would be more complicated, but I am sure the lawyers can figure it out.
It sounds like that's not something you would recommend.
We have created transactions in we have structured transactions based on multiple frameworks, including having, two or more utilities, each with their own financing order, issuing a single bond. So it is possible, but simplicity is always helpful.
Okay. Going back to my earlier question about the bond advisory body to be established, and you indicated you'd work with whatever we
Yes.
we ordered. Assuming Liberty will have responsibility regarding the structuring, marketing, and pricing of the bonds, should the commission order that an input and advice from other members of the bond advisory team be required?
It is not required. Different states do it in different ways. My only guidance I can give is that it is important that whoever be involved in the process be ready to move efficiently and quickly. We are creating a marketing and pricing process that aligns with market expectations, as well as the internal processes of investors. And to the extent you are not adhering to market standard, or you are not complying or creating a process that matches the internal investor hedging and committee processes, you may have investors that opt out of the transaction, which would result in a worse outcome for the ratepayers of Missouri.
Okay. Can you explain a little bit about what the expected process would be?
Absolutely. I would note that the process changes depending on the market environment. In more distressed markets, sometimes our process will be extended, or if there is a efficiency in the market, we may wish to compress the process to take risk off the table. But generally, once all of our marketing materials have been prepared, so that would be the registration statement, generally an investor presentation, as well as sometimes an investor term sheet, we would begin our marketing process. That process generally lasts 3 to 5 days and would comprise a series of one-on-one calls, a broad group investor call, and providing information to investors through a roadshow website. Once marketing had commenced, at some point we would share with investors initial thoughts on pricing. Those are referred to, I think, in some of these documents as IPTs, or initial price thoughts. That helps to guide investors to expectations around what the relative value of these bonds are. Depending on investor demand, investors at that point would start to place orders on the bonds. Depending on investor demand, we may have the ability to tighten our IPTs in or bring our spread in to result in a lower spread to treasuries. If investor demand is not sufficient, we may need to widen our spreads out in order to garner more support for the transaction and be able to clear all of the bonds in the market. Those decisions are made quickly at checkpoint calls with the commission, if appropriate, as well as the utility. And then once we have figured out the right price through the series of market testings, we will announce to investors that we are going to price the deal. We will notify them of the allocations, how many bonds they're going to get, and we will price the transaction and spot the relevant treasury rate at that point in time. There is then generally a 5-day period between pricing and closing, where we will finalize transaction documents, and then the utility will receive their funds 5 days post-pricing in most cases.
So from what I'm hearing, there's not going to be any time for somebody to come back and say, hey, commission, do you think this is a good idea?
Generally, the rules of what everyone is comfortable with are determined up front, and in the processes that I think result in the best outcome for ratepayers, it is everyone working together and pulling in the right direction, in the same direction to move efficiently through the process so that we can get as much investor demand as possible, which allows us to drive that credit spread in as tightly as possible and get to the best outcome for the ratepayers.
Okay. Should the commission require that Liberty, the underwriters, and an independent financial advisor deliver to the commission independent written certifications without material qualifications, confirming what they have done has in fact resulted in the lowest cost of funds and the lowest recovery charges consistent with market conditions at the time of bond pricing? So we're looking for
The expectation is that the underwriters and the utility will be providing such certifications.
okay. I believe that's all the questions I have then. Any recross based on questions from the bench, beginning with Renew Missouri?
No, excuse me, no questions, Your Honor.
All right, for staff?
Yes, Your Honor, thank you. You had mentioned or you were asked about like a bond advisory team. Have you worked with commissions that had a bond advisory team previously?
Yes.
And the team has been consisting of members of like designated staff that would be able to respond quickly,
Yes.
ideally? Okay. In your experience, has that been an effective way to alleviate concerns raised by staff or a financial advisor and help them provide guidance to the commission on the issuance advice letter once it's finally issued?
Yes.
You were asked about 2 financing orders authorizing 1 bond offerance or one bond offering. Are you familiar with the bond issuance in Texas recently where my understanding is that they securitized like all the utilities
The
costs in
ERCOT
one?
securitization, yes.
Can you explain how that worked?
That was a very different structure than what we're trying to achieve here, and due to a number of structural considerations, they were actually, it did not look like a traditional IOU securitization. I don't know that that is the best comparison if you are looking to a transaction with multiple utilities or multiple financing orders. I think probably the better comparisons would be either the first energy deal in Ohio that was issued, I want to say, in 2014, or NSTAR did a deal in Massachusetts a number of years before.
Okay, that's all I was going to ask, if it was a useful comparison or not.
I'm very aware of it. I don't know that it is the best comparison, given Texas has a different legal and regulatory framework than Missouri.
Now, you had mentioned that, if there were 2 bond offerings, that you'd have a 10 basis point increase. Assuming the approximately $145 million associated with Asbury, what does 10 basis points equate to for $145 million?
I don't have a calculator up here. Oh, maybe I do, actually. Well, it would be 10 basis points per year. I guess the duration on the cash flows is probably something, we can come back, we can actually come back and do the math for you, but it would be the duration times the 10 basis points times the total bond offering size. So, it could be meaningful in the millions of dollars over the life of the transaction.
You had estimated, though, it would be more than the $1 million in savings from consolidation.
Yes, I believe so, but I guess the point is it would be compounding the savings of consolidation.
Yeah, that's
Yes.
where I was getting to.
Yes. Yes.
Yeah,
Correct.
yeah. No further questions, Your Honor.
Public counsel.
Thank you. Nathan Williams again. In response to bench questions, you indicated that there have been securitizations below the 250 million that you indicated as preferable. You recall that?
Yes.
How low have, how much below the 200, well, I don't think I want to get it in that way. What amount of securitizations have been that have done that were below the 250 million?
So I submitted as part, I believe, of my testimony, a list of all of the transactions and relevant transaction sizes. There have been a handful of deals that have been sub 100 million, though most of them a bit older at this point in time. Going back to the inaugural Puget Sound securitization in 1997, that was $35 million. And there have been a couple of transactions that have been smaller. The goal is obviously to get best execution regardless of the transaction size, and we will be able to successfully execute a smaller transaction. It just may not price as efficiently as the larger transaction.
Thank you.
Redirect.
Thank you, Your Honor.
Judge, this is Commissioner Holden. I have a question.
Go ahead.
Thank you. Given the market volatility of late, what specific market conditions would be present that would make the bond yield disadvantageous?
Sorry, can you repeat that? The bond yield to what?
It would be disadvantageous. What conditions would be present that would essentially suggest that it wasn't worth doing?
I believe the metric that has been set is a present value savings relative to the utility's blended cost of capital. And so to the extent we had continued rate hikes by the Fed or market volatility such that investors demanded significantly higher credit spreads to treasuries, you could be in a position where the cost of the securitization exceeded historical costs or historical weighted costs of the utility. But I would note that my guess is that if you updated those costs, like in the next rate proceeding, the utility's blended cost of capital would also likely increase in line with what is happening in the securitization markets, given everyone references the same treasury yields.
Given that the Fed has already announced that they're going to increase interest rates, is there a sense of urgency to try to get this done? Does the timing of this play a factor?
I don't have the ability to foresee where rates and credit spreads are going. That said, I think taking advantage of markets when they are open is always a good practice and is the advice that we generally would give to our clients, whether they be utilities or otherwise.
Okay. Thank you, Judge.
Thank you. Any further recross based on those questions from the Commissioner? Staff? Renew. I see you not shaking heads, so we'll go to redirect.
Thank you, Your Honor. Ms. Niehaus, I apologize. I'm sure this is going to be disjointed as I work my way back through my notes here. But let's start with a recent mention you had. You were asked to comment on an ERCOT kind of combined perhaps securitization that was recent, and I think you said you thought if you start talking about a combination of orders and that sort of thing, that the more appropriate sort of reference point might be an order from 2014 or another that was older than that. Is that correct?
Yes.
So you can't think of any that would be similar to that within the last, without going back 8 years?
I cannot, no.
There were questions about sort of the implications of delay in the securitization process. Is one of the factors that can impact delay the fact that commonly carrying charges continue to accrue during that time period?
That is a factor, yes.
If we assume two separate financings, Uri, Asbury here, is there necessarily some delay for one or the other in terms of trying to move forward with those two securitizations? And I guess what I'm asking is, can they just run forward on a parallel track, or necessarily you're going to have to take one first, followed by another?
They could theoretically run together on a parallel track, and you could bring one and then bring the other when it was appropriate.
Say that again? I apologize.
So they could begin progressing their life cycle on a parallel track if the decision was made to do two separate securitizations. If one was ready to go and the other was not, you could theoretically bring one to market while the other continued on through its regulatory process.
You mentioned a $255,000 fee. Is that a per transaction fee?
I believe we were charging the structuring advisor fee per transaction, yes.
In response to questions from, I believe it was the law judge, you referenced that during the, I think it was the marketing and the pricing process, that decisions need to be made quickly. Is that a word you used?
Yes.
When you say quickly, are you talking months, weeks, days, or something shorter than that?
In some cases, it will be minutes. We will get feedback from an account. We will know that we are fully allocated for our transaction, and there will be a decision that needs to be made about whether we are ready to move forward and price the transaction. Delays outside of the normal timing are generally not well received by the investors, as they expect a certain cadence to a transaction.
Some of the questions I think necessarily went to your experience in both the utility securitization sort of space as well as your personal experience with transactions. What is your experience with utility securitization efforts?
I have the first utility securitization I worked on was in 2005 for Jersey Central Power and Light. I've been involved in the structuring and or underwriting of, I believe, 18 transactions totaling north of $17 billion in issuance.
Have these been in a variety of states?
Yes, they're across a number of states.
If you know, or if you have experience, would you describe the Missouri statute in regard to the participation of the advisor to be more or less prescriptive than other states you've worked with?
I would say it's pretty close to down the middle of the fairway.
And let me make sure that this is where I'm gonna finish. you were asked questions about the impact of the markets, is there a level where suddenly we get to a point that securitization is not, there are no quantifiable net present value benefits for the customers. And you may have been in here earlier, I'd asked Mr. Murray about this statement in your surrebuttal, where you say, while the pricing of AAA bonds will increase with general market volatility, pricing of traditional methods of financing will as well. Would you expand on that as it relates to this question of what about rising markets?
Sure. So I would say generally, but not always, markets move together, especially when you are talking about rising treasury rates or base rates. Investment grade utility first mortgage bond or other more traditional form of offering will reference the same rates and same base rates as a utility securitization. So as the Fed resets rates or rates rise, in both cases, the utility's senior cost of regular way debt will rise likely in conjunction with the rising of the utility cost of capital. Additionally, these are both high quality bond offerings, so it would not be outside of expectation for market volatility to impact both a utility's regular form of debt offering as well as equity markets, in addition to their securitization cost of capital. So I think the point you might be getting at is there may be a time disjointment between the comparison of the utilities' cost of debt and equity from their prior rate proceedings as opposed to a current mark to market on the securitization, because we would be bringing a market in today's rate.
That's all the questions I have, Your Honor. I would offer Exhibit 24 at this time.
24 has been offered. Any objections to its receipt? Hearing none, it will be received. Then, Ms. Niehaus, you can step down. I believe the next witness would be Mr. Davis. Do we need to take a little break to?
Correct, Your
get him
Honor.
on?
Yeah, he will be appearing remotely, so maybe just a 5-minute break to make sure that we have connectivity.
Let's go ahead and take a 10-minute break.
Okay.
We'll come back at 10:20.
Thank you.
And our next witness is Mark Davis for staff, and he is testifying via WebEx. And I see on my screen that he's just taking his seat, so you may inquire.
Thank you, Your Honor. Kurt Stokes on behalf of staff.
Let me swear him in first.
Oh, okay.
Almost forgot. Please raise your right hand. You solemnly swear affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth.
I do.
Thank you. Now you may inquire.
Thank you, Your Honor. Good morning, Mr. Davis. Before we get started, I just wanted to remind you again, we are recording this. We don't have a court reporter present, but a court reporter will be transcribing later from the recording. So to the extent that you can talk slowly, unlike I do sometimes, and wait so that there's no overlap. That's most helpful for the record.
Understood.
Can you please state your full name for the record?
Mark S.A. Davis.
Thank you. How are you employed and in what capacity?
I'm a partner of Ducera Partners, a investment bank.
And have you prepared in these proceedings rebuttal testimony marked as Exhibit 107 and a work paper marked as Exhibit 117?
Yes,
And do you have any corrections to make to these documents?
I do.
Can you state what those are?
Yes, on page 5, paragraph 2, line 2, I'd like to change based on the short-term or to say should be also be evaluated based on. Separately, on page 14, paragraph 2, line 3, I'd like to change exceeds to state is less than.
I apologize, Mr. Stokes. Could you direct me to where Mr. Davis is? Gotcha.
Okay, I think just for the parties' clarifications, page 14, is it line number 8?
Paragraph 2, line 3, so I believe that is line 8.
Okay.
In the case interest rates, it should now say is less than the discount rate under securitization.
Okay, thank you. With those corrections, if I were to ask you the same questions in those documents, would your answers be the same?
Yes,
And are those corrected answers true and correct to the best of your knowledge and belief?
yes.
And, Your Honor, I don't know, I think Exhibit 117 would be helpful answering some of the commission questions for. Would I be able to just lay a quick foundation for that and let the parties move on?
Please do.
Okay. Mr. Davis, can you briefly describe what Exhibit 117 is?
Yes, this is an update of underlying work papers that were attached to my testimony, updated to explicitly address questions posed by the commission.
Okay. Going to the second page, for example, can you kind of walk us through, for example, where it says consolidated, kind of tell us what that first, what each of the lines is doing there.
Yes, so on page 2, on the right-hand side of the page, under the term consolidated, this looks at a comparison of the net present value savings of a 10-year AAO to a 13-year securitization. It also looks at the implied break-even interest rate for there to be positive NPV savings under that scenario.
And then to the left on the URI, where it says URI standalone, can you just briefly describe that?
Yes, so to the left under URI standalone is a similar analysis looking strictly at the URI securitization on a standalone basis, not including the impacts of a consolidated deal with Asbury and the added amounts that would be securitized, as well as incremental fees that would be associated with an Asbury securitization.
Thank you. And then there are two rows indicated with a blue background. Can you describe the difference between those two rows?
Yes. The first row indicates the implied NPV comparison of the cases based on using the same discount rate for AAO and securitization. The second case uses a discount rate for AAO based on the carrying costs approved by the commission and uses a discount rate for securitization at the utility's weighted average cost of capital.
Thank you. And then turning to page 3 of that document, there are scenarios 1 through 4 at the top. Can you just very briefly describe what you were doing in the 4 scenarios?
Yes. So there's 4 scenarios referenced that serve the basis for a footnote in my testimony looking at the impacts of different carrying costs and different discount rates on the NPV savings associated with securitization. Scenario 1 uses the weighted average cost of capital as the discount rate and carrying cost for both Winter Storm Uri and for Asbury. Scenario 2 adjusts those amounts to use the, as highlighted with the blue arrows, use the cost of debt for the discount rate associated with Winter Storm Uri AAO, as well as adjust the discount rate for securitization to reflect the portion associated with Winter Storm Uri at that cost of debt and the portion associated with Asbury at the weighted average cost of capital. Scenario 3 further adjusts those scenarios to look at the carrying costs for Winter Storm Uri at the long-term cost of debt rate and the consolidated AAO at the weighted average interest rate or carrying costs associated with Winter Storm Uri at the long-term cost of debt rate and Asbury at the weighted average cost of capital. The final scenario, scenario 4, discounts all of those amounts, those carrying cost amounts, at the long-term cost of debt rate. So it discounts both the the Winter Storm Uri cash flows as well as the Asbury cash flows at that long-term cost of debt rate.
Thank you. And then can you just very briefly describe what pages 4 through 8, what those documents are?
Sure. So pages 4 through 8 provide a range of different terms that could be approved in an AAO and terms associated with securitization, and also evaluate a securitization of both Asbury and Uri on a standalone basis, as well as on a consolidated basis, to provide you various sensitivities around the NPV savings associated with the various assumptions that are illustrated. They further provide a look at the potential impacts of a time delay on those NPV savings.
Thank you. And then can you briefly describe the page 9 calculation?
Yes, page 9 calculates the AA or the ADIT adjustments associated with a 10, 13, or 15-year securitization, adjusting those balances to reflect the NPV of the ADIT amount, which serves the basis for the portion of ADIT that's included in the Asbury securitization amount.
Thank you. And then finally, just can you explain what page 10 is?
Yes, page 10 illustrates the cost assumptions put out by Liberty for Winter Storm Uri and for Asbury, both in terms of upfront costs and ongoing costs, and what those would look like on a consolidated basis. They further include a illustration of the potential maximum savings that could be achieved through issuing the securitization as a consolidated transaction, avoiding potentially duplicative costs to the extent they haven't otherwise been incurred.
And does that document also break out fixed and variable costs?
It does. So the starting point and the under upfront costs and under ongoing costs, the total line item for the fixed amounts, and then below those amounts are percentages associated with variable amounts. So there's no savings illustrated associated with those variable amounts, such as the underwriting fees, SEC registration fees, and bond rating fees, but potential savings associated with the fixed amounts.
Thank you. Your Honor, based on that, I would offer Exhibits 107 and 117 into evidence.
107 and 117 have been offered. Are there objections to their receipt?
Judge, I don't have an objection to the exhibits, but I question the designation of Exhibit 117 as being highly confidential. I don't see how it falls within the scope of the protective order. And I'm not advocating necessarily that it be made public, but I want to understand why it should not be.
That was going to be my question as well.
Let me lay a foundation, maybe for that designation with Mr. Davis, if I may.
First of all, is it your plan to offer this as HC or as C or?
I believe we would appreciate having it marked as HC. Is that correct, Mr. Davis, that the Commission's protective order would apply to this document?
That's correct.
And can you briefly explain the proprietary and intellectual property nature of this document?
Yeah, so this represents a proprietary financial analysis prepared, by my team or under my direction, looking at various scenarios and analyses.
And in your opinion, do these financial calculations derive financial value to you and Ducera?
They do.
And if shared with competitors or people in competition with you, would it be valuable to them?
It may be.
Based on that, we're just asking that the Commission's protective order apply and that therefore the non-disclosure agreement document apply to this document.
Judge, if I might.
Go ahead.
How would these, it says on it that they're illustrative, why would they confer potential or value to others that would compete with you?
Yeah, so the methodology and the way that, I've approached it and put it together, as well as, compared the various scenarios, I view to be proprietary in nature, and something that, could be used by competitors to, form the basis of their analysis or roles and other similar engagements.
And Your Honor, maybe some clarification might help. So the value from these documents derives from the documents themselves, correct?
That's correct.
So if somebody wanted to just cite, for example, page 3, scenario 3, showing a net present value calculation showing a net NPV benefits of 25.7 million, that would be that. There would be no problem with that, right? It would just be attaching or copying the entire document itself.
That's exactly right. So the manner that it's prepared, put together, and compared, as opposed to the illustrative assumptions that are built in there.
Okay, but the percentages and the net present value benefit derived calculations, those numbers standing alone outside of the document could be made public, correct?
That's correct.
Does that help, Your Honor?
It does, I think. And one more clarification on this. You've asked it to be highly confidential. Is just simply a confidential designation sufficient? That would make it so it's not viewable by the public or other competitors, but everyone in the case would be able to see it. Whereas a highly confidential means only the attorneys can see it.
Yeah, Your Honor, well, Dean Cooper for Liberty, I guess that would be the position that I would like to, I guess, ask Mr. Stokes to consider as well, because I think the highly confidential material was more applicable to really a different sort of market than we're talking about here. And I think that this sort of marketing information as to just kind of normal market situations fits within a couple of the categories, probably in the regular confidential rule that the commission has.
Let me ask Mr. Davis. So, Mr. Davis, on the understanding that if this document is confidential, it's not available to the public. It would be available to all of the attorneys, to the attorneys for the parties to the case, and to their hired experts. I know that there are a lot of outside experts, one from the Brattle Group, one from Utilicast, one from Goldman Sachs. Based on that, are there competitive concerns about anyone from Brattle, Utilicast, or Goldman Sachs being able to see this entire document?
So I think our preference would be for it to be highly confidential. If it would please the commission, I think sharing it with those parties is something we could get comfortable with.
I'm sorry, I didn't understand your last statement. You kind of got garbled on the line.
Oh, sorry. If you're sharing it with those, our preference would be for it to be highly confidential. If sharing it with those parties would please the commission, I think we would be okay with that.
Okay, so I take that as confidential would be sufficient? Yeah, you preferred highly confidential, but,
Yeah, I think that would be the preference, but confidential at least.
all right. We'll accept it as confidential then,
Okay.
rather than HC. All right. Did that take care of your concerns, Mr. Williams?
Sounds like I've gotten it as public as I'm going to, so I think so.
Okay. Then 107 and 117 will be received.
And I tender to the witness for cross.
Okay, for cross-examination, then, we begin with Renew Missouri,
No questions, Your Honor. Thank you.
MECG. No, thank you, Judge. Public Counsel,
No questions, thank you.
Liberty.
No questions.
All right. We'll come up for questions from the bench. Any questions from the commissioners on the line?
Commissioner Sylvia has no questions.
Commissioner Holman has no questions.
Well, I do have some questions. The first is the basic question: should the commission issue a single financing order addressing both term URI and as-rate securitizations, or should we do separate financing orders? In your opinion?
In my opinion, there's value in a single financing order, given the potential for both cost savings associated with that upfront and ongoing costs, as well as the liquidity benefits that I think have been described to the commission as well around issuing these amounts through a single financing order.
Okay, I'm going to ask you some of the same questions I asked Ms. Niehaus. What would be the effect of an appeal to a court of a commission's financing order on the underwriter's ability to proceed with the bond issuance process?
So there's the potential that an appeal could delay the issuance of all or a portion of the bonds. In doing that, the utility would be subject to interest rate risk on the value of the amount that's securitized during that time period.
Okay. Does a single financing order or two separate financing orders provide a benefit or detriment during the bond issuance process, all else being equal?
All else being equal, a single financing order would provide that.
Okay. Does a single financing order or separate financing orders provide a benefit or detriment in the event of only one of the securitization subject matters being appealed?
There would be uncertainty in terms of interest rate risk. So there's the potential for savings associated with the upfront and ongoing costs on one hand, and uncertainty around interest rate risk on the other hand. As part of the work papers that we prepared, we looked at a potential increase in interest rates of approximately 10 basis points, which were where forwards were at the time. And based on those forwards, there was still savings associated with a delay of the securitization. There's potential benefits of still issuing the entire financing together, given the potential for avoided costs in the overall transaction.
What would be the minimum dollar value of securitized property at which a reasonable underwriter would expect sufficient investor interest, liquidity, and AAA bond rating, such that the bonds are issued at the lowest available cost for Liberty's customers? So what's the minimum amount that could be financed reasonably?
I don't know that I can quantify the minimum amount that could be financed. There was reference earlier to an exhibit that's been filed in testimony with a list of the size of each securitization that had been issued back to 1997. Only a handful of those have been under the 60 million threshold for staff's proposal for Asbury. I believe 6 deals are listed in there under $60 million. So there is the potential to issue smaller amounts, albeit relatively uncommon given the high cost, upfront costs and ongoing costs associated with securitization if the deal is subscale.
Okay. how much of the estimated financing costs proposed in Liberty's petition is fixed versus variable costs? Do you know?
Sorry, it didn't come through clearly. Could you
Sure.
repeat the question?
How much of the estimated financing cost proposed in Liberty's petition is fixed cost and how much is variable cost?
So they use, and I'm referencing page 10 of the exhibit that we spoke through earlier. The upfront fixed fees are estimated at approximately $2.5 million for Winter Storm Uri and a similar amount for Asbury. And then the ongoing costs are estimated at approximately $225,000 per year fixed ongoing costs for Uri and fixed ongoing costs for Asbury. There's roughly, I showed the percentage of variable costs. I don't show the dollar amount of variable costs on page 10.
Right. In his opening statement, staff's counsel stated that you prepared quantitative analysis that compares the costs and benefits of a combined but delayed securitization with the costs and benefits of separate securitization, where one bond issuance is delayed but the other bond issuance is not delayed. Is that part of the analysis that you included in Exhibit 117?
It is.
Okay. Do you believe that having two financing orders, one for Storm Uri and a second for Asbury, will prevent a combined financing in the event that no party appeals either of the financing orders?
I want to make sure I understood the question. Did you say it would prevent a combined financing order to have?
Could you have two financing orders and one bond issuance?
I don't know if from a legal perspective, it's something that could be combined if they're issued or if they're approved under separate financing orders.
You don't know if they could be combined?
I don't.
Okay. What is your experience with bonds, specifically securitization bonds?
So I've been, since this, the beginning of this, cycle of securitizations, I've personally in my firm been, highly active within the space, advising, regulators on, either commissions or commission staff on utility securitizations. I'm currently involved in securitization transactions in 4 states with total issuance volume anticipated either through those financing orders or active processes in excess of $10 billion.
Okay. And you said Ducera is involved with this process as an advisor to various commissions, regulators. Is that what you said?
That's correct. So we don't serve in an underwriting capacity. We serve in an advisory role to commissions or commission staff.
Okay. In Ducera's role supporting public clients with securitization bonds, what has been your level of involvement in the structuring, marketing, and pricing phases?
So as advisor to the designated rep or commission finance team role, I've been highly involved in effectively all facets of that process. So involved from the early days of the designing what the process ultimately should look like and what the commission staff review process should look like, to the underwriter selection process, making sure that sufficient information is garnered by the commission staff in order to evaluate what the structure, marketing, and pricing proposals look like from the ultimate underwriter team, and then building from that to reviewing the structure of the proposal, being involved and overseeing the marketing process from commission staff's perspective, including evaluating the length of the marketing process, the steps involved, the investors that are targeted as part of that process, to ultimately inclusion in the pricing process. So investor calls, the different pricing levels, reviewing what the order book looks like, so the degree of subscription from investors into the order book, and ultimately the decisions of the utility and their underwriters around how to tighten that pricing in order to achieve the statutory objectives within the particular state's or financing orders requirements.
And did you participate in meetings with the rating agencies?
For the rating agencies, I've received access to recorded calls with the rating agencies and reviewed presentation materials that will be presented to the rating agencies. The discussions directly with the rating agencies have, in the instances I've been involved, taken place directly between the issuer or underwriter with the rating agencies, with those call transcripts or notes provided provided to to Ducera as advisor to the relevant commission staff.
In Mr. Mosendi's surrebuttal testimony, he said there should not be additional protocols or procedures added to the financing order that could lead to delays in completing the transaction. What's been your experience with the impact of protocols or procedures to the finance order? Have you seen them cause delays?
No, as it relates to the procedures that are put in place, having steps in place that provide for a organized process, outlining what the role of the finance team is, items that would be effectively reviewed along the way, and establishing what that review process looks like, in my mind, have created efficiencies in the process. So you don't end up in a world where there's a draft issuance advice letter in front of commission staff or a designated representative that could be problematic and could require revisiting various steps that had already taken place. So having those steps put in place from the onset of the process, I believe has been helpful in providing for a smooth issuance process.
Okay. In Mr. Mosendi's surrebuttal testimony, again, he states, "In my opinion, the marketing and pricing of these bonds is not fundamentally different from traditional debt securities issued by Liberty." Do you agree with that statement?
Not necessarily. So the traditional securities issued by Liberty aren't necessarily the direct or as directly tied to the ratepayer as the securitization bonds, which are 100% paid for by the ratepayer and serviced and dollars collected by the utility, but not necessarily part of the utility's balance sheet. So they're a little bit different in that regard. They're also typically marketed to a different universe of investors than you would see in traditional utility finance. So oftentimes you'll market the securitization bonds to a combination of ABS investors and corporate investors, which may be different than a corporate investor or banks that oftentimes invest in utility finance. So a bit of a different investor universe as well between the securitization bonds and corporate finance. So I think a number of differences between the two.
Okay. On page 4 of Mosendi's testimony, he infers that Ducera has implied that Liberty is unsuited to manage the structuring, marketing, and pricing process. Did you make any such statement, and if so, why? Or make such implication?
So there are natural, there's a lot of natural alignment between the utility and the ratepayers in a securitization transaction. At the same time, there's also areas where the utility and ratepayer may have different incentives, including items like a servicer fee or an administrative fee, so items that are paid directly from the ratepayer to the utility in a utility securitization transaction. So there are degrees of differences between or degrees of differences in the alignment of Liberty and the ratepayers. There's also degrees of disalignment between the ratepayer and ultimately the investor that's acquiring these securities that would look for the highest interest rate that they can achieve on the issuance, and the ratepayer that wants to pay the lowest rate effectively on the securitization. And the underwriters are in a position without any fiduciary responsibility to the ratepayer, and so there's value in making sure that the ratepayers effectively also have a seat at the table in that issuance process.
Again, on Mosindi's rebuttal testimony, page 7 this time, he says, communication with the rating agencies will generally be limited to one person from Liberty and a representative from the lead underwriter. Is this statement consistent with your experience, and what has your experience been?
Yeah, I don't disagree with that statement.
And why would that be appropriate to limit that communication?
So the communications are typically recorded, or there's any of the communications get posted to data sites that are shared with I believe all of the rating agencies through a 17G5 site, and so oftentimes the direct communication is takes place between issuer and rating agencies, but access to that information, access to what the rating agencies are asking, interested in, making sure that ultimately the structure of the bonds as proposed include the components necessary to get the highest possible credit rating, and the lowest cost are items that through that 17G5 site and access to information that's presented to the rating agencies and review of what they're asking about, that commission staff can receive information on if the structuring is ultimately appropriate to achieve the lowest cost from a rating agency perspective.
In your experience with similar securitizations, how have issues or inputs from the commission's representatives been resolved with the issuer and the underwriter?
Oftentimes through direct dialogue, so meetings established between the utility, underwriters, commission staff, and advisors, where information is reviewed. Feedback is provided either directly to the group or directly to the issuer, and then taken into account or evaluated to ultimately determine on that particular issue what, if anything, is necessary to make sure that the process is moving along forward and there's no issue with what's being proposed ultimately as a step along the way for what would ultimately be necessary to approve the issuance advice letter.
And have those conversations caused any undue delays?
No, the having a process that outlines what's necessary to be reviewed by when, and taking advantage of windows when the SEC is reviewing documents and when rating agencies are reviewing documents, provides for substantial time for staff to review information, provide input as to make sure that the issuer is able to go to market when it's ready. I've found commission staff to recognize the urgency associated with a process to the extent it exists, and I've been very impressed with the ability of commission staff to work within those timeframes in order to make sure that the ratepayer interest is ultimately protected.
Do traditional financing methods incur financing costs?
Yes.
And what would those costs be?
So from a high level, it'd be things like the underwriting fees, the legal fees, the SEC registration fees associated with those costs. The quantum of those costs isn't something that I know offhand.
Okay. Did you include those financing costs in your traditional financing and NPV scenario?
So I used the carrying cost provided by staff for the traditional rate making analysis, as well as the discount rate. In some instances, those costs or those rates include effectively the all-in cost of financing, including those amounts. But I haven't verified in this instance if that's the way that it works in Missouri.
Okay. Based on your bond experience, are these activities part of the process undertaken by the utility or issuer to place the bonds to market? First of all, selection of the underwriters, is that part of the process?
Yes.
Preparing for and registering the bonds with the SEC?
Yes.
Preparing for and meeting with rating agencies?
Yes.
Preparing for and marketing the bonds?
Yes.
And are there any other activities that are part of the process?
So I would say, broadly the structuring, marketing, and pricing of the bonds would all fit into that category. And there's a lot of subcategories I put within there, but I think broadly that would encompass the process.
Okay. Now turning to Exhibit 117, could you please explain the 4% used as the assumed carrying cost for the 13-year securitization for URI standalone?
Yeah, so 4% was an illustrative rate to when evaluating the NPV savings. I noted that the interest rate environment had changed fairly substantially from the time that Liberty had submitted testimony to the point at which I was preparing testimony. And so 4% was reflective of an illustrative assumption of interest rates at that point in time, informed by movements in the Treasury and securitizations that had priced during that, I believe since the beginning of 2022.
Okay. You analyzed two scenarios, one where using the same discount rate for securitization and the AAO, and another where you were using different discount rates for two options. Can you explain why you tested those scenarios?
Yeah, so The purpose, or part of the purpose of this analysis was to demonstrate a need to look at several scenarios to evaluate NPV savings. The different discount rates that were utilized in the analysis range from the weighted average cost of capital, which is oftentimes used as a proxy for the customer's cost of capital, to the long-term debt rate, to the extent using a long-term debt rate would be approved, or otherwise the method used in traditional utility finance. So it's looking at a range of effectively the customer cost of capital.
Under what conditions would the discount rates be the same, and under what conditions would they be different?
So in evaluating the NPV in traditional rate making, in both instances, the analysis on page 2 uses the same interest rate. That matches effectively the carrying cost approved by the commission with the discount rate, effectively indicating that in that instance the commission would be approving fair value for the cost of that capital. If there were a difference in that carrying cost and the discount rate, that would imply someone else, equity holders, are bearing the cost of under or over collection based on what the commission had approved. In the case of securitization, there's precedent for use of the weighted average cost of capital as a discount rate to evaluate the NPV of customer savings, using that weighted average cost of capital as a proxy for ultimately what the customer pays, the customer cost of capital. And so that's an alternative way of looking at securitization, where we look at it based off multiple discount rates, ranging from the long-term debt rate to the weighted average cost of capital.
Can you comment and provide an opinion on the bond advisory team concept as used in the recent Duke Energy securitization in North Carolina or in the recent California case?
Sure. Could you expand a little bit on what would be helpful related to those roles?
Well, first of all, is this something that you would recommend, and it involves the participation of the commission staff and their advisors in the bond marketing and pricing process?
Got it. Yes, I would recommend involvement of commission staff in the process from effectively the early days of approval of the financing order through ultimately the pricing of the bonds. In my opinion, it's resulted in savings for customers and helped provide comfort that ultimately the securitization would achieve the lowest cost as required by statute.
And what experience do you have with that bond advisory team structure?
As it relates to the issuances in California, it's been disclosed that my firm had advised on the last several of those transactions.
Okay. Do you have any concerns on timing or slowing down a bond issuance from using this advisory team concept?
No, I don't.
Okay. Can you explain how interest rates have changed in recent months?
Yes, there's been a substantial increase in interest rates, both both in terms of, primarily in terms of the treasury rate, but also in terms of spreads or risk premiums that investors have put on bonds.
Is it the treasury rate that was just raised last night?
The federal funds rate was raised last night, so the treasuries, aren't directly tied to that, although they reacted to an expectation that the federal funds rate was going to increase.
Okay. Do you know if treasury rates have increased in the last day or two?
I believe they have.
Do you have any concerns with the concept of Goldman Sachs acting in both the financial advisor and the underwriter roles, if that were to happen?
No, I agree. It is oftentimes typical for the structuring advisor to be involved in an underwriting capacity as well.
Can you please explain what the discount rate is?
Could you clarify the question?
I'm just trying to get a definition of the term discount rate.
I guess a rate used to determine the present value of a future cash flow stream.
Okay, and how is that determined or calculated?
It varies. I don't know that there's one standard for it.
Okay. Would the discount rate be the same as the carrying cost?
Not necessarily. It could be, but not necessarily.
Okay. Is it appropriate to use a discount rate from 2018 to determine the NPV for this case?
I don't know. I mean, it's possible. It depends how rates have moved since then.
Okay, and rates have moved since then, I guess. Okay.
That's right.
Given the potential increase in interest rates that could occur in the coming months, how would you expect this to impact the NPV comparison calculation?
So the cost of securitization would go up, relative to what it's like prior to the increase in interest rates. Looking at interest rates, if you use the current weighted average cost of capital that's approved by the commission, prior to any adjustments that take place associated with that, with the rise in interest rates, it would show a decline in the NPV of savings. There's uncertainty in terms of ultimately, what happens to that weighted average cost of capital, when it's reset by the commission. So I don't know that, anyone could say with certainty where that rate is going and how it will, change when it's, reset by the commission.
Do you agree that if the cost of securitization were to rise because of interest rate changes, that the cost of traditional financing would also tend to rise? Do they move in?
From a capital markets perspective, yes. How rates are ultimately set in the regulatory proceeding, it may take time for rates ultimately to adjust.
Now, it's my understanding that staff's position is that customary rate-making absent securitization would use an AAO amortized over a 10-year period with carrying costs at Liberty's short-term debt rate, or carrying costs at Liberty's long-term debt rate. Please explain how the short-term debt rate or the long-term debt rate is reflected in the MPV calculations included in your rebuttal testimony.
Sure. So, and I believe staff's position is currently the long-term debt rate rather than the short-term and long-term debt rate.
Okay.
Page 2 of the exhibit that we walked through at the beginning of this testimony provide that comparison of a 10-year AAO to a 13-year securitization with discount rates both at the blended cost of debt for Winter Storm Uri and the weighted average cost of capital for Asbury.
What was the reason for staff to changing its position?
I don't know.
Okay, it wasn't from your recommendation?
No.
And I'm also assuming you don't disagree with it?
No.
Okay. Okay, I believe that's all the questions I have then. So I'll move to recross based on questions from the bench, beginning with Renew Missouri.
No questions, Your Honor. Thank you.
MECG? No, thank you, Judge. Public Counsel?
No, thank you.
Liberty?
Dean Cooper for Liberty. Mr. Davis, just for a bit of context, I assume you're familiar with the Missouri Securitization statute, correct?
Correct.
And particularly the portions that discuss the participation of the staff advisor?
Yes.
Would you agree with me that at least in the statute, when it talks about the participation of the advisor, this all leads to, and the ultimate deliverable is so the commission's representative or representatives can provide the commission with an opinion on the reasonableness of the pricing, terms, and conditions of the securitized utility tariff bonds on an expedited basis?
That is, just to clarify, you're asking me, is that what the requirement of the statute is?
Correct. Is that the ultimate deliverable for the advisor according to the statute?
I would object. I would object. Calls for a legal conclusion.
I'll overrule the objection. You can answer.
I would need to check.
That's all the questions I have, Your Honor.
All right. Redirect.
Thank you, Judge. Mr. Davis, I believe you had already discussed a little bit about your experiences on bond teams. Can you generally describe the benefits from a commission having a bond team?
Yes. So the commission having a bond team provides the ability to have someone with a seat at the table looking out for the ratepayer interests along the way and avoiding instances where the only mechanism for the commission to ultimately act to protect the ratepayer interest is a relatively catastrophic event, which would be rejection of the issuance advice letter. So having a seat at the table along the way allows interim steps to ensure that the statutory requirements and meeting that lowest cost standard are achieved.
And in your experience, is that bond team also helpful in keeping the commission timely informed about all the developments in the post-financing order process?
It is.
Okay, I think you were also asked a little bit about, changing interest rates, changing cost of capital associated with changing interest rates. Do you recall those questions?
Yes.
Is it fair to say that one of the aspects of securitization is that the ratepayers and the utility are locking in a known interest rate once that interest rate is set?
Yes.
And then over the course of that recovery, that interest rate just stays the same?
That's correct.
But associated with that is a non-bypassable aspect to that charge, correct?
That's correct.
Okay. Now, flipping that over, though, to traditional rate making, is it your understanding that rates of return and interest rates in traditional rate making can vary over time?
Yes.
And is it also your understanding, though, that associated with those variable rates, though, is an associated commission review of the justness and reasonableness of those rates?
Yes, that's my understanding.
And then you were also asked about staff's change in position on the short-term debt rate.
Yes.
Is it your understanding that staff's position changed based on a misunderstanding of what the annual short-term debt rate was? Like, did staff think it might have been 0.3 per month instead of 0.3 per year?
Judge, I'm going to object to that, as he's already testified that he doesn't know why staff changed his position. I don't see that this question is inconsistent with him saying, responding to this question would be inconsistent with what he's already testified to.
I see it as a clarification rather than necessarily a change. I'm going to overrule your objection, and he can answer.
So that does refresh my recollection, and I believe that was part of, if not the rationale from staff.
Okay, thank you. And apologies to the parties and the judge for just trying to shorten that refreshing the recollection process.
That's fine. Because I believe that was testified to by somebody earlier in the process today. Yeah.
You had mentioned earlier, a federal funds rate already being anticipated in the market. Can you tell us a little bit about how the market anticipates future interest rates?
Yeah. So in particular, as it relates to the Treasury bonds, Treasury bond rates, as expectations around increased, views of inflation and federal increases in the federal fund rate, bond pricing reacted in advance of that. So as market data points came out leading up to the Fed decision, which informed investor views around could have been informed investor views around inflation, the Treasury bond pricing or required yields increased, so that there wasn't a full reaction ultimately when the Fed decision came out.
Thank you. Can you turn to Exhibit 117 again? And page 2.
Yep.
Can you go to the bottom right of that chart and kind of explain what that $25 million dollar figure represents, and just summarize how you get there?
Sure. So the $25 million figure represents the implied NPV benefits of securitization in a consolidated transaction relative to the 10-year AAO. That assumes the carrying costs associated with the AAO are 5.16%, which is the blended discount rate between URI and Asbury, and assumes the cost of securitization is 4%. For a discount rate, that assumes the discount rate associated with traditional recovery, or the AAO recovery, is 5.16%. And it assumes the discount rate associated with securitization is the utility's weighted average cost of capital, or 6.77%.
Thank you. And when you mentioned the 5.16% blended rate, can you just briefly summarize what that means?
Sure. So that uses a discount rate for Winter Storm Uri of 4.65% and a discount rate for Asbury of the weighted average cost of capital. And so the two of those amounts combined together based on their relative size implies a 5.16% weighted average rate.
And then are the calculations elsewhere on page 2 made in a similar manner, reflecting the numbers in their respective rows and columns?
They are.
Can you turn to page 3? And
yes.
So here, can you briefly describe the yellow row? It's the one that begins consolidated securitization versus AAO net present value, and the NPV savings reflected in that for scenarios 1 through 3.
Yeah, so this provides a similar analysis to what was reflected on page 2, adjusted to use a 13-year AAO, which I believe is staff's position of an AAO, and calculate the net present value of such amounts based on the carrying rates and discount rates listed directly above it on that page.
Okay. And even though staff's filed position is a 10-year AAO, you think it's still appropriate to use it like a 13-year AAO just for comparison purposes, so we're getting a big picture?
Yeah, this is a apples to apples comparison, and then the pages behind it show individual terms as well to be able to evaluate NPV savings under, if you want to use a different AAO relative to securitization term, like a 10-year versus 13-year. You can see the implied NPVs on the following pages and determine the degree of implied NPV savings.
Your last part of your sentence there kind of faded out. Could you repeat what you said?
Oh, yes. On the following pages, you can see the implied NPVs associated with a range of terms for the AAO, as well as terms for the securitization, and mix and match to the extent folks want to look at a different term AAO or a different term securitization. You can see the implied NPVs based on these assumptions, and do calculations of the amount of savings under all the different scenarios listed on the page.
I don't believe I have any further questions.
Okay. And Mr. Davis, you can step down and go about your business.
Thank you.
Mr. Williams?
Yes, please. With regard to Exhibit 117C,
Yes.
staff attorneys already represented there's information within that exhibit that is not confidential. My request is that there be made a public version of that exhibit.
Okay. The commission agrees as if you can, and file that when it's ready. Presumably it won't be before the end of the hearing, but. Okay. Use your microphone. You're not coming across very well.
Sorry about that. I forgot. While we're on cleanup, I think staff still owes Exhibit 116 to the commission. We had circulated a courtesy copy earlier with the judge and the parties, but before we actually file it, we wanted to make sure that all the parties agreed that our calculation accurately represented their positions.
Okay.
And so I think we're there. And so that should be happening today or shortly.
Okay. And if it is late filed, I give the other parties a chance to respond in writing. Okay. The next witness then is Mr. Owen. Solemnly swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, nothing but the truth.
I do.
Thank you. You may inquire.
Thank you, Judge. Elisa Greenwald for Renew Missouri. Mr. Owen, will you please state your full name for the record?
My name is James Matthew Owen.
By whom are you employed and in what capacity?
I am the Executive Director of Renew Missouri Advocates doing business as Renew Missouri.
And did you prepare and cause to be pre-filed surrebuttal testimony and the schedule to that testimony that have been marked as Exhibits 400 and 401?
Yes.
Do you have any changes to make to your testimony at this time?
No.
If I were to ask you those same questions today, would your answers be substantially the same?
Yes.
And are all of those answers true and correct to the best of your information, knowledge, and belief?
They are.
Your Honor, at this time, I offer Exhibits 400 and 401 into evidence and tender Mr. Owen as a witness.
Exhibits 400 and 401 have been offered. Any objections to their receipt? Hearing none, they will be received. And for cross-examination, we begin with MECG.
Well, thank you, Judge.
Liberty?
Yes, just a little. Thank you, Judge. Mr. Owen, on page, do you have your testimony with you?
I do.
Excellent. On page 6 of your testimony, lines 12 to 13, you state that it is your position that coal plants are destructive to air quality and overall public health. Is that your position?
That is my position at the time I wrote it, and it remains my position.
And then separately in your testimony, let's see, page 11, lines 6 to 7, you state that the price of coal-powered electricity in the United States would rise by at least 50% if public health costs were taken into account. Is that your testimony?
That is my testimony, and that is based on research I have conducted, yes.
Are you familiar with public counsel's testimony in this case, particularly during the hearing this week, that there is an American Lung Association report claiming that the air quality when Asbury was operating in that county was excellent? Are you familiar with that testimony from public counsel?
I do believe Office of Public Counsel witness Lena Mantle did testify to that, yes.
How do you reconcile that testimony from public counsel with your positions?
Well, it's interesting to me just because when I heard that, I went and looked up some information on that. First of all, the American Cancer Society has a report from June 25th of 2021 that indicates, as far as their energy policy goes, that they would recommend that all coal burning plants be shut down immediately and be transitioned to clean energy generation. That's a report from that organization. I would also note that that the American Lung Association has also looked at air quality for Jasper County and Neosho County. They give it, that is also from 2021, and they give that county a B, which still remains lower than, let's say, Greene County, which was at
Judge, I'm objecting to this testimony as hearsay. I mean, he's given results about some study. He's not provided the study. There's no foundation for the study. He's just dumping in information that's out of court statements.
Your response?
He's not my witness, but from my perspective, that it is the basis for his opinion, and as an expert offering opinion, he can rely on what would otherwise be hearsay.
And while I don't disagree with that, I don't believe it is the basis of his opinion. He expressed his opinion in his testimony, and then he said he just looked up this information.
I'll overrule the objection. You can answer.
And so to that regard, I believe that, you know, that the air quality they're saying Jasper County, even though it was recorded in 2021 as opposed to when the plant closed in March of 2020, I think still shows that there is improvement that needs to be had. Also talk about evidence in our testimony, in the SIR rebuttal testimony I provided, that shows health consequences to the population living within a 12-mile radius of the Asbury plant. So I would say I would disagree with OPC's position that this is a healthy outcome for them to have a coal burning plant near where they live.
On page 17 of your testimony, you address the public interest standard. Do you believe that the rate charged by Liberty for electricity is the only factor for the commission to consider when it determines whether or not the public interest is being served?
I do not.
What else do you believe should be considered?
I believe that and I think there's nothing that, you know, is precluding this in the securitization statute language, that there can be non-economic benefits, social costs that can be factored in to weighing the value of how we discard these energy transmission costs and seeing what kind of value that adds to the public as well.
On page 20 of your testimony, there is a reference to the Rocky Mountain Institute.
Yes.
What is that?
It is it's also a nonprofit that's based that's based in Denver, Colorado, that works on clean energy and renewable energy issues around the world.
What was the Rocky Mountain Institute's involvement with assessing the prudence of retiring Asbury or in putting together your testimony?
Yeah. At our request, the Rocky Mountain Institute did put together a analysis of this that they put online that was able to look at OPC's numbers. That was specifically from John Robinette's testimony that he filed, and found that there would be a savings of roughly $25 million for ratepayers as a result of this proposal from the company.
Thank you. That's all my questions.
Right, cross for staff.
I might put you on the spot here. I apologize.
It's what I'm here for.
But you're the last witness and the last person maybe who can answer this question. Were you here earlier today when there were some bench questions asking about, are there costs associated with traditional financing for a utility?
I think I was in the room for that.
Okay. You've previously served as the public counsel for the state of Missouri, correct?
Yeah, from February of 16 to February of 17. Yes, that's right.
Yeah, so you have experience with rate making and utility regulation.
That was my first bout of it, and I have been involved with it somewhat with Renew Missouri as well. Yes.
So in that experience, is it your understanding that the financing costs associated with traditional rate making are already embedded in a utility's rates in a full-blown rate case?
I would say traditional, yes.
Okay. So to the extent that Liberty has financing costs associated with its traditional bond offerings, those might already be reflected in rates.
They might be. It would depend on the case.
Right. Okay. No further.
Right, for public counsel.
Thank you. Mr. Owen, when you were public counsel, was there a case in front of the commission regarding Asbury?
I can't recall. There might have been. I know the only thing I remember before the public counsel at the time was a merger case involving Empire and Algonquin. That's the only thing I remember from that time period.
So you don't recall a rate case involving Empire where Asbury would have been first, gone into rates for the improvements made in 2015?
My time here was in 2016. That would have been before my time.
Well, the investment
Oh,
was part of a rate case.
yeah, that's right.
Then,
I don't remember if that was during my time or not. I would have had another lawyer working on that case.
well, did your office have a policy regarding, as public counsel, a policy that's similar to your public interest policy now about taking in social and other costs of things like coal power plants?
I don't think we had a formal position.
You formulated that after you left public counsel?
I'm saying I don't think we had a formal policy when I was at public counsel.
Well, who set the policy at public counsel?
While I was public counsel, I don't think there were any formal policies that we had in place there. We didn't have like a book of positions that we took in every case. Maybe that's the case now, but we didn't at the time I was there.
And do you renew Missouri now?
I am.
No, do you have such a policy?
Oh, no, we don't have a formalized like list of policies, no.
So you're just expressing your opinion?
I'm expressing an opinion based on the facts and the law that's applicable to each case. I think you've got to do those things by case basis. I wouldn't want to have any generalizations of any one particular area or one particular issue. I think things are more complicated and more nuanced than that. Or they should be anyway.
No further questions.
All right, we'll come up with questions from the bench. And any of the commissioners online have any questions for Mr. Owen?
This is Commissioner Kochmeyer, and I don't have any questions at this time, Judge. Thank you.
Thank you. I do have one question. Where is the Asbury plant in relation to the city of Joplin?
I believe it's in Jasper County, so I think it would have to be north of Joplin.
Okay, I know it's in Kansas.
Oh, it's in Kansas? Then I'm completely off. It would be west of there.
Okay, pardon?
Different plant, Judge.
Different plant?
Riverton is probably what you're thinking of for Kansas.
Okay, Asbury's in,
In Asbury.
I expressed my, Asbury, Missouri?
Yes.
If I had a map,
Judge, I think you can take notice of the geography or the commission can take notice of the geography of the state.
I can look at a map of Missouri and find Asbury. Okay,
There is a municipality called Asbury, and the plant is relatively close to it, I believe.
okay. I'm not sure of the value of that as evidence, but I'm not sure how important it is either. But it was just something that occurred to me this morning as I was in the shower. Okay, that's all the questions I had then. Any recross based on that question? Redirect?
No, Judge, thank you.
All right, then you can step down.
thank you, Your Honor.
And that completes the list of witnesses. I'm just going through the lists of testimony to see if there's anything we missed. Looks like everything came in for the company.
Yes.
For staff's exhibits, I show 110. Well, let's first of all deal with 112, which was Ms. McMillan's year recalculations. I show that I deferred ruling on that, I think, to allow public counsel to look at it. Was there a problem?
I'm not aware of anything.
Okay. I'll go ahead and admit 112 at this point. And then 116 we discussed. I also show exhibits 110, which is the NERC standard, 114, which is public counsel's response to staff's recommendation, and 115, which is a joint motion regarding substitute tariff sheet. Those were all pre-filed or identified by staff, but there's been no mention of them. Are they?
I won't need them.
Okay. Okay. And looks like I see everything come in from public counsel. I see MECGs and Renew Missouris have been offered and received. I believe Liberty indicated they would be filing a revised draft order. Do you know when you'll be doing that?
Judge, would the commission find that helpful to have a proposed consolidated financing order?
Yes, at some point. Is that something you'd file at the same time as your initial briefs, or?
That was my intention.
Okay. And I believe initial briefs are due on July 13, and with reply briefs on the 20th, 1 week later. Okay. And as far as the transcripts, we've been sending them on to the court reporter to be transcribed as we've been sending the recordings as they've been produced. We've requested that they be done within 5 business days, which means that the transcripts should be arriving day to day next week. And we should have them for you as soon as possible. Anything else anyone needs to bring up while we're still on the record? All right, well then, thank you all very much, and with that, we are adjourned.
Thanks, Judge.
Thank you, Judge.
Thank you, Judge. Thank you, Judge.